Shorthand dictation. Be ready for it. Start. Para. Came to be introduced. He submits that the respondent university, being a special university meant to uplift the causes of scheduled castes, scheduled tribes in particular, is fully justified in providing 50% reservation, which stands protected under Article 15 in bracket 5 of the Constitution of India. Full stop. He submits that even if the same validity of the 2006 Act has been upheld, the same does not abrogate the provisions of the 1994 Act that can still exist independently and which now stands even otherwise protected with the 2012 Amendment Act. Para. He contends that the petitioners, having not challenged the competence of the Parliament or prayed for declaring the said provisos as ultra vires of to part 3 of these constitution of the Constitution of India, the wisdom of the legislature in introducing the statutory limitations cannot be said to be violative of Article 14 of the Constitution of India. Full stop. He submits that the provisos simply preserve and contain what was provided under the 1994 Parent Act of the university, and hence all the arguments advanced on behalf of the petitioners deserve to be rejected. Full stop. He has also questioned the locus standi of the petitioners on the ground that reservation is not a fundamental right and no such rights can be enforced by the petitioners. Full stop. He then submits that the university ordinances were also laid before the parliament and there is a presumption of the validity of the 50% reservation provided for in the ordinances. Full stop. On the issue of interpretation, he submits that the provisos, if literally as they stand, carve out an expectation which does not in any way violate either the main clause of section 3 being an exception to the same and once having been included the wisdom of the parliament or the reasonableness thereof cannot be questioned by the petitioners. He submits that the purpose of a proviso is to make a provision which but for the proviso would not be in the main section, and the same can also simultaneously stand with the main section. Full stop. There is a presumption against implied repeal which is not as such. The 2006 Act does not override the 1994 Act, which is a special act. Para. Shri G.S.K. Kalia, learned senior counsel for the interveners, contends that the amending act of 2012 does not in any way affect the status of the respondent university or the reservation to the extent of 50% provided by it under the 1994 Act, which is a special act. Full stop. He submits that this special act would exist and any action taken thereunder cannot be questioned on the ground of any provision being made later on through another act of parliament. There is neither any repeal nor a presumption of implied repeal. Full stop. The first ordinances of the university have the status of law and have come to from part of the statute itself. Para 414 2020, the 1994 Act being a special law would override the general provisions of the 2006 Act as amended in 2012, the statement of objects and reasons, as well as the legislative full stop.